greetings. Welcome to our conference for the session. Our conference will begin now. Allow me to welcome and introduce the honorable members who will present their arguments and suggestions at this conference, which I believe on our right side will represent the government and the opposition will be on my left side. Before we start, please note that today's conference will be a matter pertaining to the rectification of mistake under the Specific Relief Act 1950. I believe this respective hall shall exercise the real interpretations of rectify by the virtue of this section. There will be few points that I believe this conference shall propose and oppose on the grounds of either in common law or in the Specific Relief Act itself.
Assalamualaikum, I have to the fellow judge and my opponent. As a member of the Council A of the government, allow me to present about the rectification of in the common law. Rectification in the common law is defined as a legal remedy that allow the court to make any correction when there is existing of the mistake in the contract. It's only applicable for the written agreement and not applicable for the oral agreement. This part of rectification focuses on the securing the real intention of the both parties that involved in the contract. The main purpose of the rectification in common law is to correct the dissimilarity, inconsistency and disparity that occur by the mistake in the written agreement by the both parties. That's all for my part. Thank you, my honor.
Thank you for your informative explanation, Counsel. However, pertaining to the latter case as per today, I would like to ask, is there any specific provision to apply for this remedy?
Thank you for the question, my honor. As we know nowadays, when there is an inconsistency in the mutual contract, we more refer to the Specific Release Act than the common law. It's based on the section 30 to 33 of the Specific Release Act. In section 30 of the Specific Release Act, it states that when the court found there was a mistake or fraud in the written document or instrument that is not truly show the real intention of the parties, the court shall grant the contract to be ratified. And is one to find the real intention of the parties. The presumption of intention by the parties being defined in the section 31 of Specific Release Act. It said that the court will intend the party to enter the agreement like the prior agreement at the time of the contract being made. Furthermore, the court principle for the ratification is basically to bring an agreement to be fair and justice. By looking at the section 32 of the Specific Release Act 1950, is determine the real meaning or intention in the written instrument. It must fulfill the intention of the instrument where is to be legal consequence. In addition, the plaintiff also should provide the evidence and supporting document to show that there are mistakes that exist in the written document. According to the section 33 of the Specific Release Act, and the court will consider the fact and evidence for the case before can be ratified the contract. If the evidence and proof until the proof fulfill all the requirement, the court will grant a specific enforcement to ratify the contract. That's all. Thank you.
Allow me to present a motion of rectification upon mistake. I believe that after this honorable assembly, the motion will be approved. So the words in the contract must objectively convey a clear meaning. However, if this word fails to reflect the true intention of one or both parties, then the rectification becomes a potential remedy to alter the said contract. It's important to note that the remedy exists to correct, not to improve any instrument. It serves to change a written contract to align with the party's intention when an error in recording of the condition will cause a misalignment with the true intention. We can look at the example case of SABRINA Holding Limited against US Trust Corporation Limited. The attempt was solved with the issue by altering pre-existing security agreement showcase the need for rectification when there is a disparity between the actual understanding and the written contract. Your Honor, I believe the method of rectification in cases of common mistakes underscores the importance of aligning the written document with the common intention of the parties. The law seeks to ensure that this term not align the true intention and mutual understanding of the contract are not enforced against either party to make sure that justice could be achieved. Therefore, for me, thank you.
Assalamualaikum warahmatullahi wabarakatuh, and good morning I bid to honorable fellow judges of the conference, esteemed members of opponents and my co-counsel. We appreciate the government's thorough exploration of the doctrinal basis of rectification in contract law. However, it's essential to critically assess their stance on mutual mistake as a prerequisite for rectification. Allow me to focus on the matter of mutual mistake in rectification. As we listened recently, the government emphasized the necessity for parties to have precisely the same intention at the time of the contract. Yet we contend that this stringent requirement might lead to an impractical standard, hindering the application of rectification in cases where genuine misunderstanding exists. So first, the government insists on satisfying that all parties intended to make an equitable and conscientious agreement. While we value equity, we argue that the emphasis on a shared intention might overlook cases where extension factors or evolving circumstances contribute to a need for rectification. And second, the government calls for an inquiry into the intention of the agreement and its intended legal consequences. We submit with that a more flexible approach, considering the evolving nature for contractual relationship could better serve the interests of justice. Fellow judges of the conference, allow me to submit my next points. If you refer to Section 21 of the Contract Act 1950, the government suggests both written and oral evidence to show the mistake in the instrument. We question whether this approach adequately addresses the complexities of modern contractual negotiations, where written agreements might not fully capture the parties' involving intention. Drawing attention to the case example provided, which is Vital ENP Limited and New Age Limited, we highlight the court's commitment to interpreting contracts contextually. However, we argue that the rejection of rectification in the absence of evidence of a shared misunderstanding may inadvertently discourage parties from seeking remedies for genuine mistakes, imposing an unreasonable burden of proof. So moreover, if we add in the case of Markel Bermuda Limited Caesars Entertainment, the government refers to scrivener's error as a basis for rectification. While we acknowledge the need for accuracy in documentation, we question whether the government's approach adequately considers the broader context of contractual negotiations and the potential of involving terms. So before I end my submission, while rectification is a valuable remedy, the government's rigid stance on mutual mistake might inadvertently restrict access to justice and hinder the fair resolution of contractual disputes. We urge a more nuanced approach that considers the evolving nature of contractual relationships and the practical challenges parties face in capturing their true intentions in written agreements. So fellow judges of the conference, if there is no further assist, now I end my submission here. Thank you.
As representative of MIRI, allow me to touch a little about the motion of rectification of unilateral mistakes. I believe that after the debate of this Honorable Assembly, this motion will be considered. So, my honorable judges, the first argument, contrary to what has been proposed by our respective honorable government, the issue to be raised before this honorable hall is the ground for rectification of unilateral mistakes. It should be noted that before deciding any case in unilateral mistakes, it is only one party who is mistaken and vice versa to the other party, which must be aware of the mistake. So I believe our honorable judges and my respective government acknowledge that this kind of mistake requires proof of the other party's fraudulent conduct. Therefore, it is notably that unilateral mistake can only be granted when the other party engaged in actionable conduct. So I applied the principle is nil on equity, stated that if a party knows of a mistake in their favor but does nothing to correct it, there may be a stop from resisting rectification.
I'm sorry, Counsel, I should stop you there because I heard in your arguments. So, on what grounds that you said that this honorable hall should believe you on unilateral mistake can only be granted when the other party engages in unconscionable conduct?
Thank you for the question, Your Honor. So, refer to the case of Amona Ranhil Consortium Sdn Bhd and another against Export-Import Bank of Malaysia Sdn Bhd. This is 2023 case where the court clarified that a unilateral mistake does not automatically invalidate a contract. this case outline and stand with 3 exceptions, including the unquestionable conduct. So I'm gonna state all the requirement. The first one, the exception, I'm sorry. The first is when fraud is involved. The second one is it refers to a situation where a court suspect dishonesty but stop short of finding fraud. The third exception relates to unquestionable conduct when the non-mistaken party ignores an obvious mistake or should have been aware of the mistake or fails to make the necessary inquiries when he suspects something is amiss. So everyone knows that it is clear that Section 30 of the Specific Relief Act 1950 only allows rectification of fraud or mutual mistake. However, unilateral mistakes are not mentioned. So I'm gonna apply Kamaliyah binti Momong alias Kamariah binti Momong and others against Siti Aisyah binti Hamdan and others. This is 2021 case has followed the court rule in Thomas Bates and Son Ltd against Wyndham's, where the learned judge set out the following requirement for rectification on the ground of unilateral mistake. So basically there are 4 ground, which is firstly erroneous belief by one party, second the other party is aware of the mistake, 3 the aware party fails to draw attention to the mistake, and the last one is the mistake benefits of the aware party. Mistakes concerning the nature or quality of a term may not warrant rectification if there is no established consensus or intention regarding that specific aspect. Thank you.
Hereby, I would like to conclude based on what the Council have represented by recalling them or giving a short recap on all the points that have been given. So the first thing that must be ensured or to be looked at is at the ground of which this rectification should be applied on. It takes careful thought to evaluate the rectification remedy in contractual disputes. The whole idea that I understand is that this remedy is applied based on the parties' actual agreement, and the remedy aims to fix an instrument rather than to make it better.
As mentioned by Council B in the case of Markel Bermuda Limited against Cesar Entertainment, the case demonstrates the court's willingness to examine the details of the contractual management while demonstrating a fair and impartial approach, with the court ultimately granting Markel's requested relief while taking equitable principles into account. I believe this highlights the significance of maintaining the parties' genuine intentions in contractual disputes.
In conclusion, for the act of rectification to be applied by parties, therefore parties must fulfill all the elements and prerequisite conditions as we discussed earlier. In persons, although that the parties met all the criteria and seem to be entitled for an application for the rectification itself, hence it is on the power of the court to grant whether or not it is applicable, as rectification is a remedy under the court's discretion.